through the waiting room, I can see everybody starting to flood in. So I'm going to start by just saying we're so pleased to have so many of you here.
Oh, it's started now. Brilliant.
And yeah, a very, very warm welcome to our second annual lecture and our first virtual annual lecture. To start with, just a tiny bit of housekeeping. If people could keep themselves on mute, because we have such a big audience. And when the presentations start, if you were happy to put your camera off, that will help us as well with keeping stability of everybody's poor broadband and Wi-Fi that's been working really hard this last year while we've all been working at home. So those are the first two little bits of housekeeping. I also want to introduce myself. My name's Cara Jardine. I'm part of the team here at Strathclyde. I'm part of the Criminal and Social Justice Cluster, who is putting on this annual lecture. We're really, really pleased this year to be putting on our annual lecture in conjunction with our Howard League Scotland Strathclyde student branch. So they only formed back in the autumn. They've achieved a huge amount. So we're really, really delighted to be co-badging our annual event with them. And the issue that's really at the heart of all this that's brought us all together today is the stigma and discrimination that's faced by the estimated 11 million people with a criminal record in the UK. So it's an issue that's really, really, I was going to say dear to us here at Strathclyde, but that's possibly the wrong phrasing. It's an issue of concern across both the cluster and our Howard League branch. And we're really, really delighted to have a brilliant panel today to talk to this issue from a range of different vantage points. So we've got Gerry Keogh, Keith Rosser, and Dr. Andrew Henley joining us. But before I introduce them properly, I'm just going to go through a couple of important points to kick us off. So I've asked everyone to keep themselves muted and keep your cameras off for the presentations. Our presentations are going to be 20 minutes long, and I'm going to be quite on it as a chair, try and keep everybody to time. While people are presenting, please do put your questions in the chat, and my colleague Karen Maybon, she's going to be helping me out with chat wrangling. And when it comes to the Q&A, because of how big this event is, we've got over 130 people here. I'll read the questions from the Q&A. So rather than putting you on the spot and trying to find you across the 7 different Zoom screens I've got. So please do put your questions in the chat. My colleagues from both our Criminal Justice Cluster and our Howard League Scotland student branch, they are going to be live tweeting from with the hashtag criminal records. So please do join the conversation there if you're on Twitter. And that's it in terms of housekeeping. So I'll get on and introduce our speakers. So our first speaker is Gerry Keogh. He's the founder of Unlock Employment, which is a community interest company based in Govan in Glasgow. And through his personal and professional experiences, Gerry really is an expert on the different ways that criminal records impact different people. And through his work with Unlock, where he's working with criminalised people and employers, he's really working on the front line of trying to overcome the stigma of criminal records and seek to really challenge that in a fundamental way. Our second speaker is Keith Rosser, who's both the non-executive director of Disclosure Scotland and the chair of Release Scotland. And Release Scotland is a network of Scottish employers which was started really in the recognition of the contribution that people with convictions can make and to help them to access employment to move on in life. So Release Scotland involves members from across the public, private and third sectors and actively supports the Ban the Box campaign. Keith is also a group director at Reed, which is the largest family-owned recruitment business, which in 2019 helped over 8,000 people with convictions into work. So he's, again, another active campaigner on the front line, has a really unique insight into the concerns of employers and an advocate for the contribution that people with convictions can make to business. And finally, we're really delighted to be joined by Dr. Andrew Henley, who's one of the world's and the UK's leading academic experts on the collateral consequences of criminal records. So Andrew's doctoral thesis comprised of a critical history of the consequences of legal rehabilitation for people with criminal records in England and Wales. And again, another fully engaged activist alongside his academic work. He's been a trustee and a chair on the board of the charity Unlock, which provides information, advice, and advocacy for people with convictions. And he's going to be a great last speaker because he's going to bring us from looking at both sort of moral problems and consequences of people with a criminal record to look at a more productive way of how we might handle disclosure of criminal records. So we're very, very excited. I also want to give a big shout out to my colleague, Karen Maybon, who's going to be helping with the tech. So I'm delighted to hand over to Gerry with the assistance of Karen.
Hi, thanks. Thanks for the introductions there. So, from my point of view, the next 20 minutes, I really want to talk about not so much the negative impacts, because we know the negative impacts of what having a criminal record and having to disclose it to employers. But obviously, within my field of work, I was lucky just a little bit about my past. And 10 years ago, when I walked out of prison for a sentence that I received, I actually found myself quite fortunate that I found it a lot easier than what a lot of folk actually find getting back into work. I don't know why. Maybe it was just the way that I presented myself. Maybe it was just the fact that when I'd left school, when I was 16, I went straight into work, literally within a week. And I remained in work until I was in my early 30s, until I got my custodial sentence. So maybe it was slightly different then. But then within about 2 years after getting back into work, I actually found myself working within the employability industry. And I was actually living in Birmingham at the time, based in Birmingham. It had nothing to do with wanting to work within the criminal justice field or wanting to help ex-offenders or help people like myself who'd been through the system. It was just a job. It was a job that was I was very fortunately to get into, because I found that it really changed my life, and it's had a lasting impact over me for the last 10 years. So when I started work in Birmingham, it was really just about supporting people back into employment, and that included the long-term unemployed. It included people with criminal records. There was no 10 years ago, potentially, realistically down south, there wasn't a big push with regards helping people with criminal convictions back into employment the way it is just now, the way that we see just now. But I always say to people when I talk about my journey over the last 10 years, I found myself in a very, what I call, a privileged position of being back into management, working within employability, and then actually being able to help guys and girls that were either had left prison or had just left prison and try to support them back into work. And that wasn't part of my job spec about what I had to do. I just felt that was something that it just came naturally to what we were doing. So, and we ended up having a caseload of about 5,000 clients, and out of that, probably about 20, 30, 40% of them had criminal convictions. And the biggest thing that I found when we were talking about employability, or when we were trying to help people back into work, was the fact that they had a license, or the fact that they had to declare convictions, as the big ban the box campaign that's going on and things like that. But the biggest thing that I always found when I was dealing with clients, and I deal with it up to date, even yesterday I had an email, somebody asking me about to explain what their CRB or what their disclosure was the biggest thing that I couldn't understand was that nobody that had been through the criminal justice system, they didn't understand what their disclosure was. They didn't understand when the disclosure started. They didn't understand when it finished. They knew what the impact was. And the impact was that they had to declare to an employer that they had a conviction that wasn't spent. And even actually understanding what wasn't spent and what was spent. Understanding, when I used to speak to people about the Rehabilitation of Offenders Act, before it had changed in England back in 2012, I mean, at that time, I had a 10-year declaration on my record that I had to declare. when I was speaking to guys and girls that were, you know, talking about their criminal records, they automatically assumed that that was there for life for them, that there wasn't the education side of it for me was that there was no understanding of what their declaration was, of what their disclosure was, sorry. And that for me, that hit me like a ton of bricks. I couldn't believe, I couldn't understand why, you know, going back into a wee bit of personal, when I actually got my sentence, and when I got my sentence and the day I get sentenced, I get an 18-month prison sentence. By the time I get back onto the wing, and I was speaking to the guys that were on the wing, and as soon as I told them I got 18 months, they worked out to the day I was getting released at my halfway sentence. Now, for somebody that had never been in prison, it was amazing. It was amazing how much knowledge what prisoners had inside of the running and how it all worked. So for me, that was a fantastic peace of mind. I knew then that I wasn't doing a full 18-month sentence. I was getting out at halfway. I had potentially a 3-month tag as well. So all of that was worked to the day. And actually, during that short sentence that I had, those timelines came in place. But for somebody like myself, who when I get out and I wanted to find out, you know, about my disclosure, and I started asking questions, and I was speaking to, when I was in England, my probation officer and people like that, nobody understood it. Nobody could give me the answers. So I had to then go away and educate myself a little bit about the Rehabilitating Offenders Act and understanding when it started and when it didn't. I get into work. I left that behind me. Working in the employability sector, it was just an eye-opener again for me to understand that I was working with guys and girls who were trying to get into work, whose barrier to employment was their disclosure. But for me, the massive thing about the disclosure was they didn't understand anything about their disclosure. They didn't understand when it started. And I'll repeat myself, and it's very important for that point of view, was that that then, what that led to me was like, and again, I go back to the privileged position, I always use that term, is that I started paying for disclosures for my clients that were coming in. And the reason I was doing that was because very quickly I was working with, you know, not guys and girls that were just leaving prison, guys that had, you know, had a sentence potentially 5 years ago, 6 years ago. And I was sitting there going, well, you know, when did you get out? When did you finish? And I'm going, well, do you know what? I think that may be spent. You know, that may be spent. So what we ended up doing was, and this, you know, potentially 20% of everybody I worked with that we got, that we paid for their disclosures. It was clear. And for me, that was just, you know, it was fantastic, but it was also a tragedy as well. And the tragic side of it was that we had guys and girls, and it's still going on today, that are still ticking the box to declare that they've got a conviction that's not spent. And the reason behind it is because they don't understand what it is. And that for me goes back to the, you know, even now, so I set up my own company when I come back to Glasgow, really with a passion to helping guys and girls that have got convictions, but not just that, but people that are on the periphery of going into the criminal justice system and to help them into employment. But even now, that when I speak to like job brokers, work coaches, when I speak to anybody that works within the criminal justice system, not particularly in Glasgow, but you know, all over Scotland, and I talk about convictions and I talk about the Disclosure Act within Scotland, and even now that it's changed, and even now I've been saying to people and speaking and saying, well, are you talking to your clients and understanding that, you know, have you worked out for your client when their conviction or when their declaration is going to be spent? And nobody's doing it, and they're still not doing it. And I'm not just putting my hand up and saying that I think that we're the only organisation potentially in Glasgow that are doing it, but I don't know anybody that's doing it. And for me, I understand the barriers to employability with regards to having a criminal conviction, but what we have to be doing, I personally feel, is we have to be giving guys and girls light at the end of the tunnel. And sometimes when you come out of prison, you know, either speaking through personal experience and through speaking to lots of people that went through the criminal justice system, is that they don't see a light at the end of the tunnel. And they don't see a light at the end of the tunnel with declaration, disclosures and CRB checks and the rest of it and understanding of it. But the amount of people that I've managed to support into employment just by even paying for a disclosure and then actually sitting working out and saying, you do realize that, you know, if you don't get arrested, you know, and we have open conversations. This is if you don't get arrested, if you don't get charged, if you don't get whatever, you do understand that this is going to be clear for you within 6 months. And that just opens, that there is just a complete mind blower for some people. And it's because people, when they're leaving, you know, when they're leaving prison, that conversation is never taking place with anybody. You know, I mean, I remember when I left prison, you know, I was basically told your life's over, you'll never get a job, you're only going to be good for this, you're only going to, and I won't repeat the usual whatever, but you know, as a guy who was in his 30s that went into the prison system and came out of it, it was just a mind blower for me, you know. So I managed to park all that and move on with my life and doing that. But what I see, especially, I mean, I work in an area in Glasgow called Govan. I see, you know, areas of multiple deprivation in Birmingham. I worked in Asst and Handsworth and the rest of it. We've got youngsters that are coming through the criminal justice system at the moment that are told, if you're sentenced or if you're or this, that's going to be with you for the rest of your life. And that impact, and I see it constantly all the way through. And yes, you're right, you know, the reality is that on an enhanced disclosure and an enhanced check, of course, it's going to be there. It's the same with myself, it's the same with lots of people. But that doesn't bar you for getting a job because, you know, I'd say 95% of those guys and girls, they're not going to be going into jobs that potentially need that. But even some of them that are doing it, there is still ways to redo it. But it's that whole negative connotation that completely and utterly follows someone as they walk through the criminal justice. Pardon me, as they walk through the criminal justice system. And I understand that we have to put people off with going into it. But for me, that educational side of which is why I was really pleased to be asked on this part of it, is that, you know, your criminal record that follows you, pardon me, for life, it's not the end of your working life. And the amount of guys that I get coming into me that are being referred either through job centres or they're being referred through other agencies. I work with multiple agencies throughout the city. And it's like, well, you'll never get me a job because I've got a record, or you'll never get me a job because, and I don't take that point of view. You know, my whole thought process is, let's look about a job and then let's look at the barrier and then how do we circumnavigate that barrier toward it. And some of that, I don't have a whiteboard behind me, but some of the tips and techniques that I use is that I draw a circle, I put a pie chart in it, and I'll say, right, talk to me about your offence. Give me, you know, not of what you did, but give me an overview. And I'll say, right, so that's going to bar you for this type of industry or this type of job and this type of job. Then the bigger circle, the bigger pie chart, I start writing in occupations and jobs that potentially that we can get you into. Always found that drug dealers were actually the best salespeople, you know. So then I would talk about call centres, or I would talk about an environment that, and the amount I hate to say, I won't go into personal, but that's the way that, you know, we have to. I work with people, is that we accentuate what their positives are. Now their positives may be what led them into the criminal justice system. Well, that's fine. That's fine. I'll look at that and say, well, here's an industry or potentially that we can get you into. I don't know, you may be watching at the moment, and I've got permission to kind of use his name, but one of the clients that I was working with, and he was volunteering for unlock employment, was actually an ex-priest. And literally with the change in the Rehabilitation Offenders Act in Scotland, he didn't understand it. But it changed on a week that literally cut his declaration to zero. He didn't have to declare it, and he's now working. He's now working. But I could replicate that story over a couple of hundred people across the board just by that thought process and just by talking about that. And that's, for me, that's the biggest. It's the biggest problem that I think that we have with regards records, because the reality is, yes, but other speakers will talk about, how bad and how much it hurts it. Me, I live within that world, because that's the world that I ended up walking down. That was the path that I chose. I just happened to have, when I got out, to think, right, well, I need to get a job, And when I left prison, I took a job at McDonald's. And the reason I took a job at McDonald's is when I went for my interview, I declared it to the manager. But because I was able to have that conversation and put it across, he gave me a chance, he gave me a job. But the problem that we have with a lot of the younger generation that coming through is that complete and utter negative narrative that's spoken to say, you've ruined it, you've done this, you're going to have to do this, you're going to have to do that. Whereas I believe that's true to a point. I don't go down that there, but there also, we have to start talking about the positives. We have to talk, especially now, with regards the change in the Rehabilitation Offenders Act in Scotland, is that we literally now have thousands of guys and girls out there that have no idea that their disclosure is now clear. And nobody's having that conversation with people. Nobody's, because that's thousands and thousands of clients that we can get into work now. There is a change in mindset in order to get them into work. So there's a big, I know that with Keith that's speaking later with regards Release Scotland, that I'm involved with regards to the work that goes on with Release Scotland, and it's all about the educational side of, again, with employers. And I know there's a massive talks with regards to that educational side from that level all the way down, in order to take guys and girls that have walked through the criminal justice system. But from my point of view, from having walked out the system and being involved in employability, is that when you're on the ground, the biggest challenge for me is actually getting people to understand what their declaration is. And then we go on to other avenues with regards to how do we declare, when's the best time? Do I have to do this? Do I have to do that? Do I have to? But that, for me, that's, we take care of all that. We have those conversations with people. But the biggest, I would honestly say that if you went and spoke to people within the criminal justice system that have walked through that path, do you understand what a spent conviction is compared to what an enhanced disclosure is? They won't know. They won't know. So I'm not saying that, that everybody's like that, but for me, that's the vast majority of it. But also, especially working in Birmingham, and now working obviously back in Glasgow, the biggest problem as well is that we have to change that mindset. We have to get people to understand that, the light at the end of the tunnel is, if you keep your record clear for the next year, 6 months, or whatever it is, we can get you into work without having to disclose that you've got a criminal conviction. And that there, for a guy who's in his 30s, or a guy who's in his 40s, or a guy who's in his 20s, or a young girl, that's life changing, because throughout their last 20 years or 10 years or being involved in the criminal justice system, it's always been a negative. It's always been, do you know how much this is going to impact you? Do you understand what the consequences are? Do you understand the consequences? Well, actually, when you're going to try and talk about it on a positive view and say, don't get into trouble, don't get caught, or don't get this, and actually we can get you into a full-time job. We can get you into that. That will support your family. You don't need to be committing crime to go out there and do it. And I see it all the time. I watched it in Birmingham, and I see it in Glasgow. That's probably me, actually. Sorry.
That was one, incredibly interesting, and two, impeccably timed. So you're bang on your 20 minutes. And as I said at the beginning, we're going to do our 3 speakers back to back before we open up to Q&A. But I just found that fascinating around sort of like the power of stories and narratives, whether they're positive or negative, but also how knowledge can be really empowering and accessible. Like you're saying, like people on the hall in the prison will know, like when are you going to be eligible for release? But also knowledge can be like completely mystifying. Like I totally relate to this idea of my very, very first job was working with an employability program, just thinking, I don't understand disclosure, and it's made so mystifying. So that was fascinating. Thank you.
We do. Trust me, I could sit here and talk to you for another hour about this because it's I live and breathe it. It's what it is. But I live and breathe it because, sorry, very quick, I see the power how employment changes lives. You know, that's one of my biggest passions, and it's how that's what changed my life. It's just seeing that. So I try and work as hard as I can in order to get as many guys and girls that have got convictions or are on the periphery of the criminal justice system to get them into work. I go into solicitors now and hand out my business card and say, if you can identify people that you're working with, get them to me, you know, because we have to break that cycle. That's what it is. Sorry.
No, brilliant. And there's going to be so many things that people are going to want to pick up in the Q&A.
Okay.
So I can't see Keith on my screen, but I'm hoping that he's there. And he's going to be our next speaker. Here you are. Great. Lovely. So we're ready when you are.
Thank you, Cara. Thank you for that. Yes, apologies. I've dialed in by the old-fashioned telephone as well as on the screen, so I tend to find the signal will hold up better. So, yeah, I'm delighted to speak to you all today on what's such an important subject, and actually an important subject at such a critical time. We've got some really interesting macro themes happening at the moment in the labour market. We've got more unemployed people. We've got arguably fewer jobs. We've therefore got more competition. We have more people applying for the jobs that there are. And I think there's some really important themes in there, what that means for those that are furthest away from the labour market already, such as people with convictions. We're also, of course, facing some important trends in terms of the changing nature of work and the changing role of technology to assist people finding work. And both of those themes, I feel, have a very important role to play as well in how we help support people with convictions going into work in future. They're themes that I think will continue to sort of add negative and positive bias, and how we tackle those and discuss it with employers is going to be key. So as Cara said at the beginning, I'm the chair of Release Scotland, and I'll be talking to you today about Release Scotland. It's very much about getting businesses into the debate. I always felt that the business voice was a voice that was missing in this debate. There was third sector, there was public sector, there was lots of people talking about this, but often business were the only ones that actually weren't talking about it, and they seem to be one of the most important pieces of the puzzle, as it were. So Release Scotland is about the business voice. I'm also a group director at Reed. We helped over 8,000 people into work last year with convictions. I'm a non-executive director at Disclosure Scotland. And what I would say is that Disclosure Scotland's vision is about protecting Scotland's people. And what's important about that vision is that it actually works in two different ways. It's both about protecting the vulnerable people that people will be working with, protecting employers, but it's also about protecting people who need work, especially those that have certain barriers into work, like people with convictions. So Disclosure Scotland have a very positive mission around supporting people into work, which is sometimes not fully understood, given people think they're about issuing police certificates and police records, but actually they're very committed to this agenda. I'm also the chair of the Criminal Record Trade Body, which is the trade body for all of the devolved nations' criminal record regimes, whether it's the DBS, Disclosure Scotland, Access Northern Ireland. We actually represent over 40% of all police records being produced at any one time. So we have a huge reach into the sort of employer landscape through those organisations processing police checks. And one of our key aims is also about supporting this agenda. One of my very few career highlights was that I actually got to advise then Prime Minister David Cameron on what was called name-blind recruitment at the time, which I never felt was quite the right thing or went further or went far enough. Name-blind was about taking people's information, personal information, off CVs so that it wasn't clear who was applying for a job. But of course, it often was clear based on people's education work histories, where they were from, and also key information about declaring criminal records. So I always argued that we needed blind recruitment, not just name blind recruitment. But I'll come back to that theme later. So into the next slide, you'll see that Release Scotland has always been about that missing employer voice. It's about employers helping employers. It's those who know hiring best coming together to advise other employers on how to hire. We have a view that good work has the power to affect change, and how employers have such a huge responsibility in ensuring that potential for change really is enabled across all of our communities. It is about being a voice of Scottish business to Scottish Government and consulting on changes, but it's also about business matters. And what I mean by that is that both business matters and the matters that are important to business need to be aired and understood in terms of the challenges and barriers for people with conviction getting work. And I'll return to that point a little bit later on. So on to the next slide, you see we were launched in 2018 in Holyrood. We also supported the Management of Offenders Act that was launched back in October 2020. We also contributed into the Disclosure Bill, as it was at the time, and soon to be the Disclosure Act, which is due for 2022 or 2023. Drawing attention for a moment to some of the comments we made about the Management of Offenders Act. A sentence we said at the time was that it's about removing many convictions that have no bearing on a person's suitability for a job from the recruitment process. But I want to hold that thought, because this issue of actually what does have relevance to a job, I think, is a really important one. My own personal opinion is that as a society, I think we are quite a long way behind where we should be in terms of what is relevant to an employer when choosing new people. Yes, the Management of Offenders Act, I think, is a great step forward, and I fully support it. But I think we still have quite some way to go in terms of what employers should be looking for and how employers should hire moving forward. So on to the next slide, you can see our view that as businesses need to take a lead. This war on talent, as people describe it as, in the post-COVID labour market, is going to be critical. And as we've moved through the machinery of Brexit, albeit partially unnoticed so far, I suspect that will catch us up soon. And into a post-COVID labour market, we will be back to a position where certain talent is in high demand. So actually having access to a wider talent pool through people with convictions and other marginalised groups actually is going to be incredibly important going forward. There are some studies that show that it improves retention, and firms really need to focus on that. But unfortunately, there's a lot of negative stereotypes, which I will come to shortly. So on to the next slide, I think there's a very important point I wanted to make here, which is my belief is that this is not a CSR agenda, and I have issue with people who park this as a CSR agenda. For me, this is about something that is good for business. This is not business doing good, and I think that's really important sort of differentiation, because it must be something that is done with a positive business case and not something that's done because it's marginalised as a CSR activity for some companies. Declaration of convictions, sort of how people declare, when they declare, and also what it means to declare must become more of a normalised process across the UK. There is such a varied approach to this that it's almost so varied you can't even put in a sort of standardised approach across UK PLC. The way companies ask the question, when they ask it, how they deal with the declaration is done so differently. For us, that really needs to be standardised, and some of the work we've done as Release Scotland is to put in a sort of 5 clear steps for how to do that. We also believe that at the heart of this is something we call mindset. So number one, when employing new staff, it should be done on looking at people's mindset. Mindset certainly trumps skill set. Skill set is something that can be taught, of course. Mindset is about people's commitment, about people's desire, people's wants, and people's dedication. That is hard to teach. It's a characteristic. skill set is something that can be taught, but mindset trumps everything, including whether people have got criminal records. And I mentioned it earlier about the fact we have a long way to come. You know, I think there is something quite archaic about the fact that businesses use criminal record disclosure as such a key part of their recruitment process. And as I said earlier, you know, we do believe good work has the power to affect change. So moving into the next part of what I wanted to talk about today, leaving Release Scotland aside, is we did a survey of over 1,000 employers to ask them questions about recruiting people with criminal records. And at a very high, broad top level, the results confirmed to me quite the difficulty that people face who have got convictions in terms of finding work. What you can see on the screen in front of you is the amount of people that answered no to whether they would consider hiring somebody who has got one of these types of criminal records. And people often get distracted by the sort of the real headline offences you can see at the top of the slide. And actually, they're not the ones that particularly concern me about all of this. What concerns me about this sort of cultural norm, if you like, is how people responded to questions around such things as, would you employ someone with a drug-related offence? Would you employ someone with alcohol-related offences, even driving offences? I mean, well, I was staggered to find that, you know, over 60% of employers said they would not consider someone with a drug-related offence. Almost 40% that said they would not employ someone with an alcohol-related offence. Someone once said to me a while ago that whilst 1 in 4 adults have a criminal record, the other 3 in 4 of us just haven't been caught yet. And I think when it comes to alcohol-related offences, there's something in there about, I suspect there's a number of people when they were young that perhaps did things that maybe that come back to haunt them now. And the fact that employers would still hold that as a barrier against people really was quite surprising. So to summarise that picture, I think it shows that there is a long way to go in terms of the sort of common approach and thinking within UK PLC to hiring. So on to the next slide, we asked about sort of what applies to the criteria when you are recruiting. Why do you ask? When do you ask? Why do you ask? And as you can see, there's a real variety still in place. So 40% said there's a company-wide policy to ask if there's a criminal record. Over 10% had a policy for Disclosure Scotland disclosures for all roles. About the same number saying they have a legal duty. Over 1 in 5 said that actually it's the HR department that said that. And almost 1 in 5 said local managers said that, which surprised us as well. So what this really told me broadly is that there is still quite a lot of variation in what companies do and why they do it. And this still needs to be really worked through and standardised. So the hiring picture in the UK is a much more standardised one. So into the sort of next section, which is the real bones of the survey, if you like. What we did with those 1,000 employers is we asked those that had recruited people with convictions to say what they experienced. And those that had never recruited people with convictions, we asked them, what do they expect? So you can see the difference here between the expected information and the experienced information. We then asked about 4 categories: resilience, trustworthiness, commitment, and retention. The figures on the screen in front of you at the moment are the broad view of all of that together. But before I look at that, just a few comments on each of those categories separately. So in terms of resilience, we found that those that had never recruited people with convictions overwhelmingly had a stereotype that people with convictions would be more or less resilient, and not that they would be just as resilient as someone without convictions, which we thought was quite interesting. Those that have employed people with convictions said they found overwhelmingly the same or more. So there's an interesting difference there in terms of people's expectations and stereotypes around resilience. Commitment, those that had never recruited people with convictions had a much more negative stereotype. They had 78% said they would be as or more committed for those employers that had recruited people with convictions. So those that never had recruited with convictions, they had a large negative stereotype around commitment. For some reason, they had almost a sort of cartoon-like belief that people with convictions were likely to sort of re-offend against their employer. But those that had never recruited those that had recruited with conviction had 78% as or more committed. So there's a real difference there on that one. In terms of trustworthiness, this was also interesting. Those that had never recruited people with convictions were 3 times as likely to believe they'd be less trustworthy. It's 3 times as likely those that had never recruited versus those that had to think that someone is less trustworthy. And that was staggering, really, for us in the 21st century, that people would have that kind of opinion. And then in terms of retention, what we found with people who had recruited people with convictions is they were just as likely, if not more likely, to stay in their role longer. So to summarise all of that, what was really interesting about this was how much negative stereotyping still abounded from the groups of employers that had never or not knowingly recruited people with convictions. And some of those stereotypes were really quite, if I can say, old-fashioned or archaic. The idea that because somebody had stolen once previously and got a criminal record for it, they were therefore more likely to steal again was really quite an interesting opinion. But what we need to remember is, rather than criticise the opinion, is remember that this is the prevailing sort of idea within UK PLC, and it's about how we try and change that. What we found in terms of trustworthiness for employers during COVID and the likelihood of insider fraud is that actually home working, personal financial issues for the employee or someone perhaps they live with has led to potentially more insider fraud committed by people within their company, but there is no correlation between that happening and those people having a criminal record or not. So actually what we found is the macro effects or macro motivations have been purely about personal financial situations and home working, and not about actually whether the person's got a criminal record or not. So just moving to the last few slides then. What are the employer issues then? So some of this may not be a surprise, but the sort of comments that we had that came out was adverse media, the sort of Daily Mail test. People worried that if something happened in the public eye, they would be even more criticised if it turned out the person had a previous criminal record or not. And perhaps there is something in the way the press would report on that sort of does hold true. Obviously, there is this negative bias. We've seen that from the survey that employers have at a broad level. There's concern for potential for reoffending, even though the data I've certainly seen to date doesn't necessarily support that. That seems to be something that's etched on the concerned minds of employers. And interestingly, people called out this sort of HR burden, what do they do if sort of scenario. But what also we've looked at and talked about is this obsession with perfect hires or normalised CVs. And this is becoming a growing concern of mine, certainly. This idea that people should have an ideal career pathway, no gaps in employment, standardised referencing, etc., is becoming more and more of a concern for how people get into jobs in future. And I'll revisit that just before I conclude in a moment. There was also a perception from employers that this agenda is one that's more driven by the public sector than being a good business agenda. And I think there's truth in that, and we need to, again, overturn that. So the last sort of couple of minutes that I've got, I just want to walk us through 2 more areas. One is advice to work seekers, and then one to finish with is the sort of future challenges. So on the next slide on here, you'll see our advice to work seekers. So we get asked a lot about what can I do? And you've heard from Gerry already, who I no doubt is more of an expert on this than I am. But the sort of things we as Reed and Release Scotland have said to people is, being upfront and open and honest, focusing on transferable skills, focus on what you have done and what you haven't done. We see so many work seekers, a bit like Gerry's anecdote actually about saying, but I'll never get a job, I've got a criminal record. They approach their interview or their CV in a similar way and say, well, all I can say is that I didn't work for 5 years because I was in prison, for example, rather than focusing on what they did do in those 5 years, what transferable skills they might have learned, what role they played. So focus on what you have done, not what you haven't done. Obviously, the what to declare, not to declare, Gerry has covered better than I could. So ensuring people understand what they should declare, and this bit about when to declare is important too. And if I can now just finish with the sort of future challenges, and I wanted to finish on this because I see this as an emerging risk to this agenda. COVID-19 has, in my mind, pushed those that were already the furthest from the labour market even further away. What's also happened during COVID-19 is the rise in technology, particularly the big companies, and how they're recruiting through artificial intelligence or machine learning or digitised recruitment. And what that can do, if we are not careful, is bring in a different kind of bias. It can do a different kind of filtering exercise on suitable applicants, not necessarily by asking if there's a criminal record, although some I know still do via an online sort of portal, which puts a lot of people off. But even those that don't ask the question, perhaps do abide by ban the box. A lot of this technology is finding other ways, perhaps darker ways, of selecting would-be ideal employees, and they're doing it by looking at people's career records, how long they've been in a job, what their career pathway looks like, are the gaps. And of course, what that's doing is again marginalising people who haven't got this idealised or normalised career record. So it's my urge of caution for the future. The bits on the BBC lately about new recruitment technology that have been found guilty of various types of bias, and I think we need to think about that. I'm absolutely an advocate of future change of technology, automation, and what the future of sort of hiring looks like. I sit on relevant committees in UK government about the future of hiring, but we must make sure it's done ethically, safely, and has got fairness written into the heart of it. We must also consider the digital divide, and of course those people that now might be applying for jobs fully online in our new labour market. We need to think about those where they have the greater challenges to be able to do that. So that's where I wanted to finish today. I wanted to just stress again something I've said a few times, which is about good work having the power to affect change. And I don't want to give too negative a picture, but I wanted to make the point that I think there's a lot of work to do within the employer communities to really make this a normal part of the recruitment process, and actually people having convictions being almost as normal, dare I say trivial, as declaring credit information or gaps in employment history. I think for me that's got to be where we get to the position of with sort of declaration of criminal records. Thank you very much, Cara.
Thank you so much. I just think I enjoyed that so much. I was still on mute. I was carried away listening to you. And I think some of the figures in that are absolutely astounding. But what I really liked is that kind of connection to the macro and what that means for the needs of business and changes in the labour market going forward. And also that idea that if 1 out of 4 people have a criminal record, 3 out of 4 haven't been caught, that also connects this macro of, because we know there are certain groups and communities that are more likely to be criminalised, more likely to be policed. So there's so much food for thought in there, and the chat is buzzing. There's a couple of questions in the chat about recording. Yes, we are recording presentations. We're not going to record the Q&A, so don't be shy about your questions. It would just be the presentations that are recorded and we'll make available when they're ready. So without further ado, I'm going to pass over to Andrew, and I think this is set up really nicely for his presentation, thinking through these bigger ideas about citizenship and sort of the worth and value that work can bring.
Thank you, Cara. With me just 1 second. So thanks, Karen, as well for sorting out the slides for me. I get to channel my inner Chris Whitty today by asking for next slide, please, at various points in the presentation. So that's going to be fun. Good afternoon, everyone. First of all, I'd like to just express my gratitude to Beth, Cara, Karen, and colleagues in the Criminal and Social Justice Research Cluster at the University of Strathclyde, as well as the student members, of course, of Howard League Scotland for their kind invitation to contribute to this annual lecture. I'm also very grateful to Gerry and Keith for their fascinating contributions and for doing much of the heavy lifting in a way for me by talking about the complex relationships between criminal records and employment in their remarks. And in a way that's given me the space to perhaps provide a broader look at the so-called collateral consequences of criminal records in my 20 minutes. I'd also very much like to thank you all, the audience, for taking the time out of your day to come and listen to what we have to say on the topic of criminal records. And upon discovering that the event had sold out, I will confess to an overwhelming sense of fear that I'd be relying as much on the strength of my broadband connection as the intellectual integrity of my arguments to communicate my thoughts on this issue. But once the fear had dissipated, I was really heartened actually to learn that there were so many people out there who were interested in this topic. So once again, thank you. So kind of on that point, if we can go on to the next slide. In many ways, the strength of interest in today's panels rather taken me by surprise insofar as the scale of publications on the topic of criminal records and stigma or discrimination as associated ideas is rather overshadowed by those the more established elements of the carceral continuum. Drawing here on the completely unscientific method of typing stuff into Google Scholar, I just want to illustrate here, however crudely, that in the last 10 years alone, the balance of publications is focused very much on the tip of the punitive iceberg, with some 160,000 odd publications mentioning prison and prisons or imprisonment in connection with the different nations of the UK. You see those in yellow here. Searches for probation, community supervision, community sentences, or as it's more encouragingly described north of the border, criminal justice social work, returned in the region of 20,000 odd publications, and you see those in green. However, the poor relation to the poor relation in terms of scholarship is that which focuses on criminal records and stigma or discrimination, with only about 3,500 returns that you see there in blue. And as I've acknowledged, this is not a robust method at all, but a crude attempt on my part to acknowledge, at least that as social scientists in the UK, we've got a lot of catching up to do compared to our colleagues across the Atlantic, where scholarship on this topic is in a much more advantageous position to document, analyse and critique the intricacies of what Ruben Miller and his colleagues have described as carceral citizenship. If we can move on to the next slide, please, Karen, thank you. My other purpose in drawing attention to that issue is to demonstrate that the relative scholarly attention paid to criminal records when compared to those other areas of penological focus is nowhere near comparable to the numbers of people that are potentially affected by them. So this data is a bit more robust, and we see here that around 88,000 people are incarcerated in Scotland, Northern Ireland, Wales and England combined. We have in the region of 242,000 people subject to some sort of community supervision or social work order. And there are 11.8 million people, about 1 person in 6 in the total population has a criminal record on the police national computer. And in many cases, this includes information which, despite the provisions of the Rehabilitation of Offenders Act 1974 and mechanisms that might filter certain convictions from disclosure certificates, it could potentially lead to the less favourable treatment of or active discrimination against people who may have long completed their sentences and gone on to lead law-abiding lives, the very people that Gerry and Keogh have been talking about. If we can just move on to the next slide now, thank you. So drawing on Fergus McNeill and colleagues' conceptualisation of rehabilitation coming in distinct forms, it's possible for us to see how an individual may attempt a project of personal rehabilitation. They might recognise the harms caused by their prior wrongdoing as part of their bargain in relation to their moral rehabilitation, but ultimately be denied the kind of informal social recognition and acceptance as a returning citizen necessary for their social rehabilitation. And that's on the basis that their legal rehabilitation has not yet formally been certified, and the post-sentence restoration of full citizen status is held in abeyance, if indeed it was ever enjoyed meaningfully prior to them coming into contact with the criminal justice system. So former lawbreakers, I would argue, are thus too often cast at the end of their sentences into a state of civic purgatory, by which I mean that whilst they're waiting for their legal rehabilitation to occur, they're no longer strictly an offender to be punished, managed and supervised by criminal justice agencies, but they're also not able to enjoy unencumbered access to the full range of rights and entitlements that citizens ought to. And if we just move on to the next slide, this is very significant insofar as, you know, that we need to almost problematize this language of collateral consequences in a way, because in some senses they're not merely collateral, but they're central in some senses to the processes of punishment that are built upon moral stigmatization. I mean, indeed, for many people, and I'm sure, you know, Gerry might know people that would say this, that what comes after the sentence in some ways is worse than what happens during the sentence, all right? So it doesn't necessarily feel collateral to them. And quite often, you know, reflecting on what Keith was just saying, they're not automatically a consequence, you know, these kind of forms of less favourable treatment. A lot of discrimination that happens is not legally mandated, but it's part of an active social process of discrimination, which involves a whole range of actors, particularly employers, making decisions to treat people with convictions less favourably than others. So drawing on Gresham Sykes's work on the pains of imprisonment here, I'd argue that we also need to think about pains of criminalisation, right? Things that accompany acquiring a criminal record. And, you know, across the UK, these pains include, but then by no means limited to, sort of forms of deprivation around areas like, you know, employment, civic participation, international mobility, and you can see them all listed there on the slide. I don't have the space to go through all of them, unfortunately. I'll go through the ones in blue, but just a shout out at this point to an excellent blog post by our PhD colleague at Nottingham, Charlotte Brooks, who's doing some work on access to higher education and how that might potentially be impacted by a criminal record. So hopefully someone will put the link to that in the chat so that you can all access it. So we'll talk about a couple of these different pains of criminalisation in turn now. So if we can move on to the next slide, please. Now, as I've said, Gerry and Keith have done all the heavy lifting here, talking about how employment might be restricted, but I thought it was just worth showing this to add a bit of extra context. So a shout out also to my friend here, Marty Rivera, who provided me with this data. But what we're looking at here is some evidence around the prevalence of criminal background checking. And these are requests for criminal records in a range of different countries, not for judicial purposes. So this is not for the purposes of the criminal justice system. This is largely in relation to decisions around employment. And what you've got here across time is what seems to be like a fairly international phenomenon in terms of the growth of requests. All right, now the rate is not the same everywhere. This is showing the rate of requests for criminal background checks per 100 inhabitants in each country. And it's not the same rate everywhere, but the general trend seems to be upwards. Yeah, and so this is something we're really going to have to think about how we respond to this with better mechanisms for protecting those individuals from unnecessary discrimination. If we can move on to the next slide, please. So another potential pain of criminalisation might be restrictions on people's mobility, and obtaining visas to travel to many non-EU countries has often proved difficult for people with convictions, particularly getting visas to get into the United States and Australia and elsewhere. That can be an issue that we don't often consider. Post-Brexit, UK nationals are going to have to apply via an ETIAS scheme, and for the most part, that seems to be concerned with individuals with terrorism-related offences, but we're yet to kind of see how that's going to work out in practice. But I think it's worth just mentioning another kind of facet of people's kind of right to exist in different places. You know, under the Borders Act, foreign national offenders are liable to deportation as well. So if someone sentenced to more than 12 months imprisonment will normally be liable to deportation. And there's an interesting, you know, piece written by Milena Tripkovic in the British Journal of Criminology. It's just appeared, you know, considering to what extent the denial of citizenship in that way is truly a punishment or not. Whereas even if it's not formally codified as punishment, it certainly would feature as an outcome of criminalisation that's very serious. And we've also seen quite recently how the Home Office hostile environment policy has actually swept up a number of people that actually had rights of residence in the UK in relation to the Windrush scandal. So that also, you know, does need to be considered too. We can move on to the next slide, please. So another pain of criminalisation, I would argue, is a denial of civic participation. So we know quite a lot about prisoner voting rights in that debate, and there was a fantastic, thanks to Hannah Graham for highlighting the discussions that happened in the Scottish Parliament around this issue only yesterday. So go and look at Hannah's Twitter feed if you need to find out about that. But there are a whole range of other areas in which that might be an issue for people. So there are restrictions on eligibility for election to public office, for instance, you know, becoming a local councillor or whatever. The example that you see here on the right, this guy Bob Ashford was prohibited from standing to become a police and crime commissioner for Avon and Somerset because I think 47 years earlier he'd received a £2.10 fine for trespass on a railway and possession of an offensive weapon, which was an air gun. Which, although he only got a very small fine, they're technically imprisonable offences under some circumstances, and anyone with an imprisonable offence on the record can't be a police and crime commissioner. So despite having worked for decades and doing all sorts of fantastic work in the youth justice sector, he was forbidden that opportunity. And there are also, you know, other examples might include being barred from jury service or, you know, volunteering in all sorts of ways in their local community. Or even becoming a charity trustee, for argument's sake. There may be difficulties that arise from that. If we can move on to the next slide, please. I would say in many ways, one of the most egregious examples of the pains of criminalisation would be what I call almost like the denial of victimisation. And what I'm talking about here relates specifically to issues of criminal injuries compensation. Now, one of the things that the Criminal Injuries Compensation Authority is supposed to do is to award compensation to victims of serious crime. Yeah, and we found that in 2017 to 18, SECA applied the applicant's criminal record or character as a rejection criteria to 1,894 different applications, right? Of those, 1,599 resulted in no compensation being awarded to that individual at all because of their criminal record or background. And in the remaining 295 cases, compensation was significantly reduced for people who were victims of serious sexual assault, those who had suffered significant scarring. Some people had suffered a total loss of smell or taste, and some had serious facial disfigurement as a result of their injuries, and they were denied or reduced compensation because of their criminal background. And the quote that I've got on the screen in front of you here, this is when an individual who was the victim of a chromic acid attack, someone turned up at their house and mistakenly they had got the wrong person, but they threw chromic acid into this person's face at close range. And you can imagine like life-changing injuries. And then they were refused compensation because of their unspent criminal convictions. Now they attempted to challenge this, and this is an extract from the tribunal judgment that said, you know, in all sorts of areas of government policymaking, it's legitimate and appropriate for those with unspent convictions to be treated differently, right? So it's almost like a kind of tacit acceptance that, you know, you got what was coming to you almost in some degree. You know, you're not as worthy as consideration as another person because of your criminal record. Next slide, please. So we need to start thinking about, well, what might an alternative approach to criminal records look like? And background checks, you know, for employment are often, you know, generally used as a crime prevention measure on grounds that a conviction might be a good predictor of future offending. But that's not necessarily true in all cases. Their kind of predictive validity, as it were, tails off over time. And there are a number of time to redemption studies, as they're called, which kind of measure the extent to which an individual with a conviction becomes almost like statistically the same or less risk than somebody else in the population. Right, so the point at which a person really becomes no more likely to be convicted of another crime than someone that's not been convicted before. And there's an excellent summary of those that Beth Weaver put together, you know, a few years ago that's definitely worth checking out there. But I think it's also important to kind of recognise that, you know, the vast majority of people that acquire a conviction do so only once. Yeah, so the Ministry of Justice did a big cohort study of conviction histories, and they found that by the time people get to 53, about a third of men and about 9% of women acquire at least one conviction. However, 52% of the males appeared in court only once during that time, and a further 17% only twice, okay? And for females, 75% appeared only once, and 14% twice, right? So the vast majority of offenders appear to only get in trouble with the law once or twice. and then they kind of settle down to lead law-abiding lives. So the idea that a criminal record is like, this perfect predictor of what's going to happen in the future is not necessarily the case. Of course, there's a distinction to be made between proven reoffending rates and actual rates of recidivism, but nonetheless, this kind of large-scale data does tend to suggest that people really, for the most part, experience a brush with the law and they don't become hardened criminals posing a long-term risk to the public. So I'd also say in relation to criminal background checking that there are a range of kind of sort of moral reasons, as it were, why we need to kind of think differently. Okay, so and I think sometimes it can be a bit disappointing to hear only kind of like very utilitarian advocacy for reforming the criminal records regime, which is about we need to do this in order to reduce the costs to the taxpayer of reoffending, or we need to do it, to protect the public from the recidivism of people. Because as we've just said, like the vast majority of people that get a conviction are not reoffending. So I think we need to kind of turn to more kind of fundamental or deontological, if we're going to get philosophical about it, arguments around justice and fairness. And so there's a few things that I'll just say here. So my colleague Zach Hoskins at Nottingham, he's Cara earlier was very kind and saying that I was a leading expert in, I'm not even sure I'm the best expert on this topic in my university, because Zach's amazing, right? And his book is well worth checking out, where he rehearses some of the kind of moral arguments against illegal restrictions in particular on people with convictions. And I think he's made a very compelling argument to say that quite often these restrictions are not grounded in morally relevant reasons, and the status of someone being an ex-offender alone is not sufficient to justify differential treatment. And he kind of argues in part that on the basis of the fact that they've served their punishment and been held to account for their actions, the notional debt to society that they may have incurred should be regarded as paid. Yeah, and there's a problem if we then continue to hold that against them, and we might actually render the sentence disproportionate in some senses by imposing additional burdens post-sentence on an individual. And Christopher Bennett at the University of Sheffield's argued that collateral consequences are normatively unjust because they not only affect what John Rawls called the basis of self-respect, but also because they demonstrate a neglect of the fact that we have kind of associated duties to people with convictions, their families and their communities as fellow members of a kind of shared democratic enterprise. And by not actively, attempting to bring them back into the fold, there may be a problem there. And to this, I'd just add that the imposition of this sort of state of civic purgatory following a sentence may undermine perceptions of the legitimacy of penal sanctions from the perspective of people with convictions. Now, a sense of frustration is likely to be experienced by those who engage willingly with rehabilitative activities whilst in custody or the community as part of their sentence. They do all that's required of them, only to find that their engagement's not then reciprocated by the state in an equal claim to social goods enjoyed by other members of society. And I think there are kind of links here with some of Cara's work, actually, where she's talked about how imprisonment might affect like the sense of legitimacy that family members and others associated with people in custody might feel, right? And so in some ways, the excessive burden of collateral consequences are kind of corrosive of the very legitimacy that, the criminal justice system seeks to gain for itself in that sense. So what's to be done? Okay, we're getting there. Next slide, please. So how to think differently about this. So I'm going to draw in and probably do great violence to his ideas in the process, the work of John Rawls. Okay, so for Rawls, fundamentally, justice is about fairness. And he does this to kind of solve problems of distributive justice, but I'm going to try and apply it to this idea of how we can think differently about doing disclosure and treating criminal records. And what Rawls argues is quite interesting. He proposes this fourth experiment that he calls like the original position and the veil of ignorance. And the idea is this, that if we were going to devise rules that are fair and that are just for a future society, we'd have to do so from an imagined original position where there was no society yet. We had to think it almost like blank slate, and we had to position ourselves behind a veil of ignorance. And what he means by that is that we'd have to not have any awareness of what our position would be in that future society. right? So we wouldn't know whether we're rich or poor. We wouldn't know if we're male, female. We wouldn't know whether we're black or white. We wouldn't know whether we're more or less attractive or more or less talented. And I'd add, we wouldn't know if we had a criminal record or not. Might be another criteria then, right? And under those conditions, we're forced to devise rules that have to take into account the possibility, well, it might be us. It might be us, or it might well be a member of our family that could be vulnerable to less favourable treatment. So the rules that we create have got to be fair for all. Yeah, and we don't just think from the position of the majority, we kind of align ourselves with the individual who might be disadvantaged. Okay, so I'm basically going to say that under those conditions, I think that people will come up with these 4 principles. So if we can move on, last slide, we're on the home stretch. So these are kind of like 4 R's in a way, all right, to make them nice and easy for everyone to remember. I would argue that most reasonable people thinking from behind a veil of ignorance would agree on a general principle of retraction. And this holds that following the completion of their sentence, access to information about the existence of any conviction should really be drawn back in such a way as to respect the privacy rights of a person with a conviction and their families, of course, with the aim of protecting them from discriminatory conduct. Under that principle, access to criminal records, of course, should be strictly limited to perhaps policing and judicial purposes, and a general right of public access would be deemed impermissible. And I'm thinking here particularly of the situation in the United States, where people can go to court and drag up conviction records. There's a bit more protection in the UK, of course. And I'd say that, in a way, official records of convictions could also be subject to processes of deletion or sealing after an appropriate period, in accordance with the other principles that I'm going to set out. And so where non-criminal justice actors wish to consider prior offending history for employment purposes or to safeguard vulnerable people, this should be perhaps facilitated through the provision of a clearance certificate by the appropriate authorities and not through the disclosure of the full criminal record. And the Dutch have an interesting system here whereby they issue certificates of conduct, not a criminal record disclosure. Yeah, and there are limitations on the extent to which one is provided. And so, decisions about whether or not to issue such a certificate could be made following the other principles, one of which is the principle of relevance. And this would hold that once the sentence has been served, any less favourable treatment of people with convictions can only really be morally permissible where some kind of close nexus exists between the nature or circumstances of an offence and the purposes of the inquiry about the criminal background. So you might think sexual offences and working with children, right? Or you might think embezzlement and working in a position as a kind of financial advisor or actuary. In that sense, there's a close nexus there, yeah? However, if officials judge that the principle of relevance is satisfied when determining whether or not to issue a clearance certificate, they should then also act in accordance with the 3rd principle for fair treatment. And this I call a principle of recency, right? How recent is the conviction? And the principle of recency advocates for an evidence-based assessment of whether the age of a relevant conviction is likely to still be predictive of any higher than normal likelihood of similar future offending occurring. So we know from time to desistance studies, yeah, that there seems to be a shelf life for the predictive validity of convictions. If they don't have predictive validity anymore, what is the actual value in terms of public protection gain of disclosing that, yeah? And so that principle could help us to govern decisions about storage, sealing, or deletion maybe of criminal records in accordance with the principle of retraction. And then finally, I'd also argue for a general principle of redeemability. And by this, I mean that no individual should be subject to permanent exclusion from the possibility of being legally rehabilitated based solely on the nature of their offence or the sentence imposed. Thus, all people with convictions should be able to maintain a right to hope that they might ultimately be able to benefit from the legal protections available in their respective jurisdiction. However, this principle would not necessarily advocate for a right to automatic legal rehabilitation for everyone, but instead recognise that for some exceptionally grave cases, a system based upon an application to an appropriate authority, such as a parole board or a judge, as in the French system of judicial rehabilitation, could offer the opportunity for that person to evidence demonstrable personal change and a recognition of the harms caused by their offence. And then that principle would act as an incentive to good conduct for those convicted of very grave offences following the completion of their sentence. And you might say, well, that sounds wildly utopian. It might be a very high bar for some individuals, but nonetheless, there should at least be the prospect of that happening, I would argue. And in some senses, we do have that kind of principle. So, for instance, with sex offender registries in this country, some people are subject to indefinite notification periods, as a result of the length of their sentence. But after 15 years, they have a right to apply for that to cease. So we do have a general kind of sense of a mechanism like that being a possible thing. All right. So what I'm basically saying here is that, there are features of these different principles that seem to exist in the UK and in other countries around the world. But I've not seen too many countries which I would say kind of respect all of them. And so perhaps what we need to move towards is a kind of hybrid model where we use these as a mechanism for kind of like evaluating the fairness or the justice of the disclosure arrangements that are in place. And I think that's my time up. So at that point, I'll stop talking and look forward to hearing what people have to say in response. Thank you.
So thank you so much for that. That was absolutely fascinating. And you were absolutely spot on about where my interest in this would be. And I was just thinking with that quote from that judgment where our lawmakers are saying it's legitimate and appropriate to treat people differently. I was just sitting thinking, yes, but according to who? And, legitimate to who and by what measure? And so there's so much to unpack. And thank you very much. I really enjoyed that. I have been grouping questions in the chat because we have so many and more than we could ever get through.